In this video, I'm going to show how to do a claim. In some countries, there's a specific claim form, like the UK, it's an N1. Just put N1 claim form in Google, you come up with this. If you don't have a claim form in your country, a lot of European countries are quite happy for you to simply write your own claim. So start with who you are, your name and address. If you don't want to put your address because you're a vulnerable person, homeless, anything like that, that's fine. You can do a separate document to the court. Otherwise, put your details, put their details. So let's say it's a hospital, and it's never the name of the person, it's the name of the hospital. It could be a state government organisation like the Ministry of Health, and move on down the brief details of the claim. Let's say if you're a client and you've had medical negligence, you would write that. If you are a provider like a midwife, doctor, nurse, you've had bad employment and you've been taken to court unfairly, you might want to take a claim against the people for malicious prosecution. You can only do that if you've already won that first case. But whatever the case you're taking, you might just want an apology to fix something in law and not money, but it has to be with a value for the courts to look at cases, and that's what makes changes. So put in a value, say 10,000, and you can change the value later, and here you put what the court fee is. Many people are exempt from court fee if they're unemployed, if they're on low income, and the fees are waived. If you've got a legal representative who's a proper person registered in that country, you can pay them and then claim that money back if you win. If you lose, the risk is you also have to pay the costs on the other side, which is why people often don't take a case. However, drafting a case is very therapeutic, and you can send it to the other side without filing it with the courts. So there's no cost, no risk, and the other side might engage and they might not. It may be a bluff that you're going to file it or not, but you could file it at any time you choose to. You repeat the details of the defendant on this particular form, so it's in there at least once, maybe twice. Then you give, if it's going to be London, Vienna, Moscow, New York, Paris, wherever the court centre is going to be. You have an opportunity on the back of this form to put brief details. And if, for example, you're a vulnerable person, you could put that. This could help protect the person making the claim, because people do feel very vulnerable with claims often. There is an element that's often overlooked, and that's the human rights. So let's say there was medical negligence, but in addition to that, you have a right to private and family life. Somebody treated you or your family badly or wrong in a hospital, say it was giving birth, they coerced and forced them to have treatment they didn't want, they had side effects or reaction or infection, for example, from the unwanted and unconsented medical treatment. So that would be a breach of private and family life, Article 8 of the United Nations Convention on Human Rights. It might sound complex to know all these laws. You don't. There's a few basics, and that's enough. And you can get somebody to read through this afterwards. This particular form, you put some particulars of your claim, what the legal causes are, like negligence or assault, battery, trespass to the person, whatever it was. And you can do both, attach and to follow. So you could write a longer thing. I suggest focus on facts, take out emotion. Some emotion will come through anyway. Then you make a statement saying, I understand what I've said is true and accurate, and if there's anything I've made a intentional mistake and misled the court, I know that I am liable for prosecution. So if you show that you understand that, then it's signed by you as the claimant, and it can even be electronic signature. If you have somebody representing you, then they can also sign it on your behalf and indicate clearly who they are, where they work, and you have to put the date that you signed it. So if somebody's representing you, they put their details, or again, your own. That is it. Then you can go to this button here and you download it with your changes. So up here, there's an option on the British form to put where you're going, like London, Manchester, whatever. And this box, if you're exempt from fees, you go online and put exempt from fees, and it takes you through a few questions, and it will give you a code, a number to put on this form. Whatever country you're in, you can apply to be exempt from the court fees. This can help if the case goes against you and you lose it. If you've been reasonable in taking it, the judge may not award costs against you. There is a risk of costs being awarded against you. They may be significant. But if you're on low income or on benefits, like unemployed or something, then there's no point making costs against you. And if they did, it could be a small amount per week or per month. But if you've already been exempt from paying for the claim form and the application to the court, you very likely be exempt not exactly exempt, but again, there's no point making somebody pay if they can't pay. So then you give this to the court, you get procedural advice from the court. How do I give this to you? Is there an email address? It used to be in paper in triplicate, so 3 lots of all the papers. It's so much easier. If you're doing it online, you've written a Word document, save it as a PDF because it reduces the size drastically. Courts want small volume. So you've got your documents and you've got lots of separate documents, merge them into one document. You can cut and paste them. It must be one document, saved as a PDF, and the index for the document is much easier and helpful to the court if you've hyperlinked it. You can research the word hyperlinked. So all that means is in the index, I might put the word my statement, and then lower down where it has my statement, I highlight that, bookmark it, and link that to the index. I can do a separate video on that. I'd be interested in any comments and questions. You send it to the court, they will seal it with a stamp, and then you or the court, it's usually your responsibility as a claimant, to file it. After it's filed, serve it on the other party and have evidence it's been served. And that nowadays can be done easily with electronic email rather than somebody turning up at an office and giving it to them. But make sure it's served. And they have got 14 days, they become the defendant. And this is critical. This shifts you being a victim of a miscarriage of justice or something's gone wrong, bad treatment, to them having to answer within 14 days. They may get an extension of another 14 days, but certainly within 1 month, they have to have given their defense. And if they haven't given a good defense or whatever, it will go to court. And at least having the threat of litigation might get them involved in mediation. That's a common theme. The threat of litigation gets mediation, and they may settle with you outside of court. If they don't, you go to court, you stand by the facts that you've put in your claim form, and any additional material, get witness statements from others, expert witness statements, put them together in what's called a bundle, a call bundle. And you'll have skeleton arguments. It's a funny name for an argument, but it means don't talk too much, just give the brief details. Again, focus on the law and the facts and put them together. So I'm going to stop here and post this and ask you to send me your comments and questions.